The document that your North Carolina family is going to fight over is almost never the one that you think it is. It's not the will, it's not the trust, it's that one-page beneficiary form that you filled out 15 years ago and never looked at again. Here's what North Carolina families need to know before that one-page form does some damage. Beneficiary designations override your will and your trust every single time. It doesn't matter if your will or your trust specifically references that specific financial account. If the beneficiary designation says someone else's name, the designation controls. If you haven't audited your beneficiary designations in the last 3 years, the conversation is going to be more useful than this video. Link below. The beneficiary designation on a financial account creates a contractual obligation between you and your financial institution to pay the money or the account to a named beneficiary if you pass away. The clerk doesn't review it, the court can't override it. Your family can sue, but they're probably going to lose because you submitted a valid binding contract, a designation with your financial institution, and their obligation is to follow that instruction. So it doesn't matter if so-and-so said you were supposed to get that money. If it doesn't name you on the designation, it could cost you months, if not years of litigation, lots of out-of-pocket litigation expenses, and a ton of hurt feelings if that designation's wrong. There's 3 accounts that most North Carolina families get wrong at some point. First is the 401k with an employer that you worked at maybe 5 or 10 or maybe longer years ago. Maybe it was your first job out of college. Maybe you were married to another spouse at that time. The designation might have said that spouse or your parents, but not your present spouse, not your present children. And we just forgot about it. The second is an IRA rollover from a prior employer. Same idea. Maybe the beneficiary designation was appropriate when it was the 401k with your employer, but once it got rolled over to your financial advisor, the beneficiary designation was just never up to date. And the third is life insurance with your employer, that group life policy that everybody gets as part of being an employee of that company. Maybe you listed your parents or your prior spouse or your kids directly and didn't intend to. Your current spouse gets cut out inadvertently. Now, with beneficiary designations, it's important to understand how to use them and when to name people outright and when not to. We want to name specific people when it's our spouse or our adult children who don't really have anything going on that would impact their ability to own or possess or control money. They're mature and capable and financially ready for wealth. We want to name a trust for the benefit of our beneficiaries if they're not that. Maybe they're minors. Maybe they've shown some irresponsibility or likelihood of being taken advantage of. Or maybe they have a disability. In that instance, we want to use a trust to receive the money instead of them outright. And third, an estate. We almost never want to name an estate, our own estate or anybody else's, as the beneficiary of a financial account, unless it's a really intentional elder law strategy. At Cary Estate Planning, our goal is simple, just to make estate planning easy. Click the link below to start the conversation. Now that you know what to do and not to do, how do we figure out if our own beneficiary designations may be in trouble? We can start by pulling all of our existing statements. Maybe you just got them at the end of the corner, and seeing if the statement indicates if there is a beneficiary listed on the account. Alternatively, you can log into your different financial platforms like your 401k provider, your brokerage account, your bank accounts to see if there are beneficiaries listed. Last but not least, and if all else fails, you can call the financial services companies directly. There are customer service lines, your financial advisor or private banker at your bank branch location. We're looking for indications or confirmation that there are beneficiaries listed on your account and who those beneficiaries are. And of course, update accordingly if they're out of date. Now, it's important not to forget depth on your beneficiary designations. Many North Carolina families fail by only having a primary beneficiary listed on their account, and they never fill out the contingent or alternate or secondary beneficiary. If that person named as your primary doesn't survive you, then that designation fails and the assets in that account will end up going into your probate estate. We want to take the time to not think through only the obvious things. Think past the obvious. What happens if this ideal, primary beneficiary does not survive us? The cleanest estate plan on paper doesn't really matter if the beneficiary designations don't match. This is the audit that should happen every 3 years or so, or after any major life event. If you want us to walk through yours, link below. The next video breaks down the Secure Act's 10-year rule, the change that quietly reshaped inherited IRAs for every North Carolina family. People's biggest mistake isn't failing to plan, it's failing to update. Make sure your plan is ready when it matters most. Give us a call and schedule your consultation.